Hi, my name's Isaac Shutt. I'm an estate planning and probate attorney who's licensed to practice law both in Texas and in Wyoming. And in this video, we'll talk about probate. Now, first of all, what is probate? Well, probate is the process of proving something. In fact, probate comes from the Latin word, I believe it's pronounced probare, which means to prove. And so what we're doing is we're proving something. So when we talk about probate without a will, we're proving who the heirs are. When we have a will, when we're proving something, we're proving the validity of that will under the law. So that's what probate is. So the probate court hearing and how that will go will really depend on whether or not there's a will. In this video, I'm going to talk about what a standard will probate court hearing is like. So this is if someone's passed away and there's a valid last will and testament, and you're going to go to that probate court hearing, which is typically required. What do you expect? What are you in for? What is this going to be like? Well, first of all, let's talk about who's going to be at that hearing. Well, you're going to have a judge. And in the bigger counties like Dallas and Harris and the bigger, more populous counties, you're going to have a dedicated probate judge who does nothing but probate cases. And in fact, their label is probate judge. And in other counties, you're going to have a county court or county court at law that has probate jurisdiction, and they'll be your probate judge for that day. And so either way, you're going to have a judge in the room with you. You're also going to have your probate attorney. Most will probate cases will require you to have a hearing. So you're going to have the judge and the probate attorney, and then last and certainly not least, you'll have the proposed executor. Now, when a person comes in to hire us to handle a will probate, usually that person is the executor named in the will. So the people in that courtroom for that probate court hearing will be the named executor, which is our client, the probate attorney, in that case, me, and then the probate judge. Generally, there's not a huge crowd, but it kind of depends on the particular court setup and whether or not there are dedicated probate courts, which usually don't have a big crowd, or if it's a county court where the courtroom might have a bunch of people in it. Now, also keep in mind, we're still kind of here in 2023 coming out of COVID. And so right now, a lot of the probate court hearings are being conducted via Zoom, which frankly, our clients love. They don't like to physically go to the probate court courtroom. So I don't know how long some of these courts will continue to permit the probate court hearing to happen via Zoom, but some of the probate judges still do allow the probate court hearing to happen via Zoom. But let's just talk about what's going to happen when you start that probate court hearing. Okay, so the first thing that's going to happen is the judge will call the case. So he's going to say, I'm going to call in the matter of the estate of Smith. And typically you and your probate attorney will go to the front of the courtroom. Sometimes you'll go all the way up to stand right in front of the judge, and sometimes you're going to go to the attorney's table where there's a microphone. But one way or the other, the judge calls the case and you're going to come forward. Now, from there, the judge is going to ask you to raise your right hand and swear that you're going to tell the truth and the whole truth, and you know the deal. And so that's called swearing you in. Now, after that happens, your probate attorney is going to ask you a series of really simple yes or no questions. So they're going to ask you, is it true that your father, Tom Smith, died on September 29th, 2023? And you'll say, yes. And isn't it true that he died with a valid last will and testament? Yes. And so you're just going to go through those questions one by one. And what your attorney is doing is basically checking off all these boxes that the estates code requires. Because the judge can't probate, meaning you have not met your legal burden in proving the validity of the will until all those legal requirements have been checked off. So that's what your attorney is doing, is he's helping the judge see that under the law, we've checked all the boxes and that it's a valid will. Now, that question and answer thing, that should not intimidate you. In fact, most probate attorneys like us will hand you a script for all intents and purposes before you even get started. So it's not like when you start that hearing, you're going to be surprised by any of the questions that your attorney will ask you. They're softball questions to begin with, but even then, I sort of like to rehearse with my client before we even go into the hearing, because these are uncontested hearings and we're allowed to talk about what is expected at the hearing. So before the hearing even starts, I'll typically rehearse so my client knows exactly what I'm going to be asking. So you'll have this question and answer where the attorney is asking you these questions and the client is answering. You're answering these questions. And there's typically between 10 and 20 questions, all no-brainers. And then sometimes the attorney missed a question or two and the judge knows that. And so the judge may ask you some questions that the attorney may have missed. Now, after you've answered all of your questions, if it truly is a valid will, the judge then will make the ruling. And usually that judge will say, it is now the order of the court that the will is admitted to probate and that Miss Smith here is hereby appointed as the independent executor of the estate. And that's pretty much it. In fact, most of these probate court hearings are minutes long. Sometimes as short as 2 or 3 minutes. Sometimes the judges like a little bit more formality and can take maybe 10 or 15 minutes. But the probate court hearing itself is really lightning fast. And a lot of our clients after the probate court hearing look at us and go, was that it? Which to me is sort of a compliment. If that hearing goes so fast and so smoothly that the client goes, that was way easier than I expected, that means that we've done things right, okay? But that's the way most of these probate court hearings go when there's a last will and testament. So I should note that even though that's a pretty easy and non-intimidating probate court hearing, if you have a valid last will and testament, I can't tell you what it's going to be like in your case if either there was no will or if the person passed away with a wonky will. Because a lot of times people come into our office and they say, look, mom did her will and she got it off, whatever, LegalZoom, whatever, Rocket Lawyer. You've heard all those websites. And unfortunately, a lot of times we have to deliver some bad news and to say, you're not going to get that easy will probate court hearing that you were hoping for because maybe the will's not valid at all, or maybe it's valid, but it's kind of broken in some way. And so when we have those sort of weird cases, you're not going to get that quickie, short 2-minute hearing. We're going to have to do some sort of damage control, which sometimes under the law means we're going to have a witness or 2 witnesses that need to come and participate in addition to the executor in that probate court hearing. Or if the will's not valid at all, it's a whole different probate court process called a determination of heirship, which is a whole different subject for a whole different video. So that's a different type of probate when there's no will. So this video was really just to say, that will probate hearing, when we're dealing with a good, valid will, is lightning fast and is not intimidating. Usually your attorney will tell you the list of questions that you'll be asked during the hearing. The judge calls the case, you raise your right hand, you answer some softball questions from your probate attorney, and then the judge makes the ruling that it's a valid will and you're appointed as the executor. That whole probate court hearing process can take anywhere from 2 or 3 minutes to maybe 10 or 15 minutes, and it's really nothing to be worried about. I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed to practice law both in Texas and in Wyoming.